Mr. Frank will explain that the respondent's encounter with Agent Gomez did not constitute a seizure under the Fourth Amendment, while I will explain that my client's acquisition of the respondent's cell site location data did not constitute a search under the Fourth Amendment. Your Honors, this case involves a federal agent's attempt to protect the public welfare in a manner that was both reasonable as well as constitutional. We therefore ask that this Court reverse the holding of the 14th Circuit for two reasons. First, there has been no violation of the respondent's constitutional rights. And second, the constitutional right that the respondent claims was violated was not clearly established at the time of the alleged violation. To my first point, Your Honors, there is no constitutional violation because a search under the Fourth Amendment simply did not occur in this case. And the standard by which we evaluate whether a search has occurred is, of course, from Katz v. United States. And we know that the respondent must have possessed not only a subjective expectation of privacy, but also an objective one in order for a search to have occurred. And in this case, the respondent possesses neither. Regarding the subjective expectation, it could hardly be argued by the respondent, who is in his 20s, that he did not know that his cell phone was periodically telling his phone company the approximation of where his cell phone was. That is how we assess such things as roaming charges and data plans, and whether or not we have service at all. For example, if I were to enter the subway in Manhattan, I would have no service. But if I were atop the Empire State Building, I would likely have full service.
You're suggesting he would know and fully appreciate that his cell phone rendered him subject to being located anytime he used it?
Yes, Your Honor. And that goes to the, even if the respondent did not know subjectively, objectively, under this Court's jurisprudence, under the third-party doctrine, it actually does not matter if the respondent did not know that his phone company would eventually give up that information to the authorities. In the two cases that have put forth the third-party doctrine, United States v. Miller and Smith v. Maryland, the individual made that argument. He did not know that the government would eventually give up this information to the government.
No, I don't think. I'm sorry. Are you suggesting there's an age distinction, where someone in their 20s would not have that expectation, where some old folks like us would? Is that the suggestion?
No, Your Honor, certainly not. But it would be harder to argue that an individual who likely had a cell phone since he was 13 did not know that the location of the cell phone is determinative of what service he has provided, and that the cell phone company knows the approximate location of the cell phone.
Well, the fact that a cell phone company records roaming charges would not necessarily lead someone to know that there is a concept of a tower and that a quarter-mile radius is recorded and it's maintained on the records of this third-party provider. What do you have in this record which suggests that on an objective basis or a subjective basis, someone would know, or this person would know, that there is such a record down to that level of precision?
It actually, Your Honor, it actually does not matter if the respondent knew there was a record. And the argument, a very similar argument was made in Smith v. Maryland, and the Court responds to that argument by patently denying it. And the Court stated, quote, it does not matter. The third-party doctrine applies, quote, even if the information is revealed on the assumption that it will be used for a limited basis, and on the assumption that, on the confidence that the third party will not turn that over to the government.
How about the other part of the question? What is there in the record which would lead us to conclude, either objectively or subjectively, that somebody would know that their location within a quarter-mile radius is knowable?
The record does not indicate whether the respondent knew this, Your Honor, but actually this is an easier case because the respondent actually does not know what information he is actually claiming a privacy interest in. At least, for example, in Smith v. Maryland, the police attached a pen register to the individual's landline at home, and were able to understand what phone numbers he was dialing. At least in that case, the individual was able to argue that he knew the phone numbers he was dialing and claimed a privacy interest in it.
But why should he not have a right of expectation of privacy with his cell phone?
He may, Your Honor, but as soon as he voluntarily purchases the phone, leaves it on, and
he relinquishes that right?
I'm sorry?
Purchase?
The voluntary action of purchasing the phone, leaving it on, and requesting service by leaving it on, gives the information over to the third party, which under this Court's jurisprudence for decades, hold that there is no objective expectation of privacy in
significance of the towers is so that you, or the prosecution, can draw the conclusion for the trier of fact that that individual was within a set distance from that tower. It's not simply where the signal is being drawn, correct?
Well, technically, Your Honor, it is. We know that the cell phone is within that distance, not the respondent itself. And that actually goes to the second theory on which we base our argument, is the holding from United States versus Knox, that once an individual reveals things to the public on public thoroughfares, streets, and sidewalks, he cannot claim a privacy interest in any of that information. There are certain enclaves that are protected by the Fourth Amendment, such as the inside of a car, or what is in a private letter when you give over the letter to the United States Postal Service, or in your home, of course.
But doesn't he take that phone into those locations?
He did, Your Honor, but it did not expose anything else that could not have been known by regular surveillance. For example, the United States...
But you're not suggesting that regular surveillance would be the equivalent of what we had here, namely 30 days worth of information about where he was using his phone.
It would be the equivalent, Your Honor, if the DEA felt it necessary to tail the respondent for those full 30 days.
Have you ever heard of a case where anybody tailgated somebody for 30 days?
No, Your Honor, but the fact that it's possible, and that's the crucial holding from the United States versus Knox, is that if it is possible and hypothetically possible to tail the individual in the public thoroughfares, that it is not, it does not implicate the Fourth Amendment. And the reason for that is, in the United States versus Knox, the police officers put a tracking device in an object that the individual was about to buy without the knowing. And they tailed the individual and eventually apprehended him, but for 1 hour they actually lost visual of the individual. And the only way they were able to know where he was because of the technology. So the implication from that is, if it is hypothetically possible to have tailed him, then it is not unconstitutional to amplify your senses. And that's what this court stated, that police efficiency is never equated with police unconstitutionality. The police is simply enhancing their senses, their investigative senses, by using information that the respondent voluntarily gave away to a third party.
But are you saying there's no boundary at all to what surveillance on the roadway is compared to the individual taking the cell phone into his home or into a synagogue or to some other like facility? There's no difference here?
There is a boundary, Your Honor. Firstly is, of course, the Shared Communications Act. This is not a carte blanche for the government to look at everyone's cell phone information just because they feel the need to. There is a standard that must be satisfied in order for the magistrate judge to grant that order. And it was satisfied here, but it is not a blind surveillance.
It's not blind. When does the government cross the line?
When it becomes so specific, Your Honor, that we are able to know the specifics of what is occurring in the respondent's home.
But this happened in the desert. I mean, the reason they caught the guy was because basically they could determine that the site, the tower involved, was in the desert. We went there Tuesday and Thursday, invariably, for 7 hours. And the ability of the government to do that turned on their getting access to what he thought and believed was private information.
That's certainly what happened in United States versus Miller. In United States versus Miller, the government was actually able to gain access to the individual's bank records, which he, of course, thought would not be turned over to the government. And that exposes a lot about an individual, what he purchases over the past 30 days. But that was not unconstitutional.
But there wasn't a distinction there that the records that belong to the bank does not necessarily belong to that individual. It's the bank's business records. That's a distinction, isn't it now?
And these are business records here, Your Honor. And in fact, in Miller, the bank was required by a federal statute to keep those records. So the government required the bank to keep the records and then invoked the summons in order to acquire the records that were require an announcement of a constitutional right by overturning over 60 years of case precedent is demonstrative of the fact that the right that the respondent would want this court to announce was not clearly established 12 months ago when this incident occurred. The point of qualified immunity is to allow our police officers to take action without the fear, the constant fear of monetary damages. That is a distinction, of course, in this case, because this is an individual being sued. This is not the government. This is not a suppression hearing. The respondent sought in the district court monetary damages for what was alleged violation by my client, a police officer that acted not only pursuant to an order by a magistrate judge, but that order was made pursuant to a congressional statute. No reasonable officer would think under those circumstances that he was violating the law with those two levels of security that surrounded his actions. And not only that, Your Honor, but this is an issue of first impression for the 14th Circuit where this incident occurred, as well as this court itself. So to argue that this was a clearly established right that my client must have known that he was violating the law is a stretch for the respondents to argue.
Why shouldn't your client be responsible for decisions that have been made outside this district, simply because this issue's never come before this court before? There are lots of other decisions in other districts that have indeed determined that this was an illegal search in similar circumstances. Why shouldn't your client be responsible for that?
Well, to answer your question in two parts, Your Honor, even though there have been several district courts that have held that this is a search, there are equally a number of district courts that have held the opposite. And there are only 3 circuit courts that have dealt with this issue, 2 of which hold that it is not a search. We wouldn't want our police officers to be responsible for district court holdings in Texas or California when in their own circuit and in their own district, this is not yet an issue. And it is not a clearly established issue by any means. The point is to allow our police officers to take action without the fear of repercussions. And when you act pursuant to a congressional statute and a judge states in an order that what you're doing is legal, reasonable, and constitutional, my client should by no means